Okay, everyone, this is video lecture number 1 for the makeup class for September 12th in evidence. I'm going to apologize in advance if you hear a rooster crowing in the background. I do live on Mount Tam, and our neighbors decided that getting a rooster was a great idea. So if you hear that, that's why. Okay, so I am starting PowerPoint 3. I believe this is slide number 15 for those of you who are wondering where I'm starting here. So this is the slide about Rule 405B in particular. Now, we started talking about this whole topic of character evidence last week, and this is always the time when evidence students figure out that this class presents a lot of moving parts. And so I want to go back briefly to start here to the wrongful death hypo that we did in class last Wednesday. Now that hypo, which I'm going to show you on the next slide, is really designed to be an example of Rule 405B in action. Now remember, I told you 405B can be thought of as a special exception to this basic ban that we have on character evidence, the general ban. And I think, as I told you, that 405B should be thought of almost as a standalone rule. So the text of the rule says, when a person's character or character trait is an essential element of a charge, claim, or defense, the character or trait may also be proved by relevant specific instances of the person's conduct. And remember that the fact that 405B uses this word also here in the rule means that when character or character trait is an essential element in these rare cases when it can be proved by character witnesses that are talking about the relevant person's reputation in the community, or the character witness's personal opinion of that relevant person's character trait that's listed in 405A, but also if the character trait is an essential element, evidence of specific instances of the person's conduct in the past can also come in, which is really a special circumstance. So on this slide, remember, I put a bunch of examples of types of cases in which character could be said to be directly in issue in the case. I don't actually have on this list the concept tested on in the hypo, so really in your notes you're going to add that case type to this list to watch out for. So here in our hypo, we have our widow bringing that wrongful death action, and she's asking for damages here, not only for this financial support her husband would have offered over his remaining lifetime, but also money for loss of his companionship and such. So under either federal or California law, like I said in class last week, the character evidence rules here generally allow a defendant in a wrongful death action to introduce evidence of the character of the deceased, of the decedent, when the survivor is claiming damages based on this loss of a happy and affectionate marital relationship. And also sometimes when that character evidence might indicate that the deceased wouldn't have actually financially supported the plaintiff. So really, it has been allowed under those two theories of relevance there, direct evidence about past acts. So I'm offering this as another example where character is actually placed in issue by the plaintiff here in a wrongful death case. So this is going to be considered an essential element, and Rule 405B is going to apply here. Now, I think the wording in this question was also possibly confusing to some students, since the way it's worded, it asks you, it tells you that the trial court overruled the plaintiff's objection and asks you whether the trial court's overruling the objection is correct. Now, starting next year, I'm going to change the wording on this slide to just read, should the trial court admit the evidence. It actually doesn't change the meaning of a yes or no answer to this question, but I think looking at it that way, yes, do you think the evidence should be admitted, or no, it shouldn't be admitted, makes it at least clearer what question you're answering. So again, what we had here was an affair that lasted 3 years and that ended 6 years before the decedent's death, right? And we had a check-kiting conviction for which the decedent served a year in jail, and that happened 3 years before his death. So I thought in class you all came up with great arguments on both sides here. This hypo is a perfect example of an evidence question that can be argued both ways and that a court could rule both ways on admitting the evidence or not. So if you were frustrated here by there not being a clear right answer, then welcome to evidence law, because that's sort of the way it is. But if we're looking here only at character as an essential element in a wrongful death case, I personally would agree with the folks who voted yes, that in our hypothetical situation, both of these pieces of evidence should be admitted. They both at least can be convincingly argued to be relevant to whether the plaintiff really had a close and loving relationship with her husband at the time of his death. But we brought up the fact that despite basic relevance being a pretty easy call here, if you imagine that character is an essential element, we talked about the fact that Rule 403, or in a California case, the California version of Rule 403, our code section 352, that those rules give us an argument against admission of the evidence there in our hypo. So don't forget to consider that always on an exam essay answer. Now in class, I mentioned that this hypo is based on a real California case from 1972. The name of that case is Carr, C-A-R-R, versus Pacific Telephone Company. I told you that in that case, the trial court allowed the evidence in, just like all of us who voted yes on our hypo. On appeal, the appellate court conceded that yes, in a wrongful death action, a widow does put at issue the pecuniary value of the marital relationship between herself and her deceased husband, and that makes any character traits that would have affected that relationship relevant. And the court actually said, the appellate court actually said these were potentially relevant to both the loss of companionship damages and the damages for future financial support. Now I'm going to put the short appellate opinion in the Carr case onto Canvas in case you're interested in taking a look at it. But in the actual Carr case, the facts were a little more extreme actually. The affair was, just as in our hypo, between 9 and 6 years before the decedent's death, but it was a bit more sordid factually. The affair was actually with a 16-year-old girl, and apparently there was a statutory rape conviction there. Now, in the Carr case, the California appellate court there was reversing for a new trial based on something else entirely, but then basically told the trial court what to do with all this character evidence on retrial, which is why the character evidence was discussed in detail. Now, the appellate opinion said that the proffered evidence of the decedent's acts of conduct there in 1961 to 1963, the affair, and in 1967, the jailing for the check-kiting offense, to prove his character traits was too remote and too far removed from the decedent's family relationship in 1970 when he died, and therefore the probative value of that evidence was lessened by that passage of time, and in this case was outweighed, substantially outweighed, by the danger of undue prejudice under the California counterpart to Rule 403. So that the trial judge should have sustained the objection and excluded the evidence. But as you'll see if you read the opinion, the court does suggest that it would be okay to allow in allow in evidence that the decedent didn't support his family for 3 years and then again for 1 year, and in fact even saying that for 3 years the decedent was separated from his spouse and did not support the family, and then again was separated for another year. So the court is actually suggesting sort of a redaction of the details of the affair and of the reason for the jail separation as a way to counter the possible prejudice. Now, I'm not sure how much precedential value today in California this 1972 Carr case would have, but the point again of the hypo we did in class is to show you that you can be creative with arguments on both sides of a close issue like this. And that's exactly what I'm going to expect you to do on an exam. The way the evidence was described in our hypo, with sort of less sordid details, to me, if I were a judge, I would probably say they're worthy of admission, probably the affair evidence more than the jail evidence. And personally, I think nowadays for an appellate court to say that admission of these incidents was an abuse of discretion would probably be a real stretch here, since it really is a high standard of review there on appeal. So for an appellate court to reverse a case based on a trial court's admission of this evidence, I think would be a stretch. And frankly, I think even in the 1972 case, if they weren't already reversing the case on other grounds, they may not have reversed the case just solely on the grounds of admittance of this evidence. But again, for your purposes in this class as evidence students, and for those of you who want to be litigators or trial lawyers, learning to see both sides and thinking of all possible arguments is really the main point of the exercise. So that, along with the reminder here to make sure you always consider a possible Rule 403 or California Evidence Code 352 exclusion of character evidence that might seem to fall under one of the exceptions to the character evidence inadmissibility rule, you just have to consider all of that. It's always going to still be within the judge's discretion to exclude that evidence if the risk of undue prejudice, waste of time, etc., substantially outweighs the probative value of the evidence. Okay. So now I have skipped ahead, I think, 3 slides. So after we did that hypo and finished up our discussion of Rule 405B, that sort of standalone rule, we then moved on to character evidence used as circumstantial evidence, right, as propensity evidence. So remember, Rule 404A1 gives us the general rule that generally evidence of a person's character or character trait is not going to be admissible to prove that on a particular occasion the person acted in accordance with that character or trait, right? So you can't put in evidence of a person's character or character trait to say, oh, look, this person has this character trait, so they probably did the thing that we are accusing them of doing in this case. But then we saw 404A goes on to give us some exceptions to that general rule. We saw illustrated in the Mickelson case the exception that is here in Rule 404A2A, and that is specifically for criminal defendants. So we saw a criminal defendant can put on evidence of his good character trait if it's relevant to the crime with which he's charged. And the justification for allowing criminal defendants to do this is that the defendant should have the right to argue that committing this crime is inconsistent with his character. That is the reason we let criminal defendants sort of start the ball rolling and offer positive character evidence. But the next part of Rule 404A2A tells us that if the defendant's character evidence is admitted, Now the prosecutor can offer rebuttal evidence to that positive character evidence. So, the prosecutor can only talk about a criminal defendant's character if the defendant first puts his character in issue by presenting positive character evidence. So we don't let prosecutors bring in bad character evidence against a criminal defendant in every case, because obviously we have our concerns about juries using this evidence impermissibly and convicting a defendant for reasons other than the prosecution proving the crime on trial beyond a reasonable doubt. Right? So again, the defense is the only side that can start offering character evidence in order, as we said, to somehow say, look, jury, I'm a fine, upstanding citizen, and it makes no sense that I would have ever committed something as awful as this crime that I'm charged with. So again, that's allowed under 404A2A. Now, we need to look at Rule 405A because that sets forth the rules about what kind of evidence a defendant can put on to try to show his good character. Again, the rule here is that the defendant can't put on evidence about specific acts he's done in the past to show his good character. So the rule now in modern times under our federal rules is that character can be proven by a character witness testifying about the criminal defendant's reputation in the community for that character trait, or about the witness's opinion of the defendant's character. And here again is the actual text of Rule 405A with the relevant text of the rule in bold there. Again, remember that Rule 405B is not going to be relevant to what we're talking about here because that is only applicable for that small subset of cases where character is an essential element. Okay, so looking again, though, at Rule 405A and the fact that we're allowing testimony about reputation or opinion, I just want to point out that this is different from the common law rule we saw illustrated in the Mickelson case and that you also saw illustrated in the Teddy Roosevelt excerpt in your book. Remember, back then, the law restricted positive character evidence to testimony only about reputation, didn't allow personal opinion testimony of the witness. And I talked a little bit about this last week. This reputation testimony was thought to represent the accumulated wisdom of a community, and so it was considered to be more reliable than just the opinion of a particular person, right? There's that quote in the opinion about the shadow a person's daily life casts in his neighborhood in the Mickelson case. And certainly over time, this restriction basically became outdated. You know, people move around more. The idea of someone's reputation in a community has become a little bit more quaint and less reliable. And I think also, if we're really being honest, this so-called reputation evidence, even when it was given back in the day, probably mostly just represented the witness's opinion in disguise, right? I mean, certainly a criminal defendant trying to take advantage of this rule would only put on a character witness whose personal opinion was that the criminal defendant had good character or that good character trait. So the rule makers and our federal rules basically take a broader view than in the Mickelson case or than at the time of that Teddy Roosevelt excerpt, and allows the testimony to be given in the form of either reputation or opinion testimony. So now a character witness in a criminal trial testifying for a defendant can say, I know the defendant well, and in my opinion he is, for example, a very gentle person. But the witness can't go on from there and talk about how the defendant always captures flies and lets them go outside instead of swatting them, or how he helps old ladies across the street, because that is specific act testimony. That's not allowed. And, you know, really, that is the case despite the fact that if we're being honest, specific act evidence maybe is the best kind of evidence of a person's character. Certainly past acts are maybe the best predictor of future acts. But of course, the big trouble with specific act evidence in this circumstance, specific acts of positive character, is that it's going to tie up a lot of time. If this was allowed on direct exam by the primary character witness proffered by the defense, the witness might start by stating her opinion, then she'd be asked, well, why do you have that opinion? She'd start talking about events and experiences, and then that's going to necessitate probing those events and experiences, and you'd end up in a big quagmire, probably. The use of specific acts evidence on direct could end up necessitating inquiries to establish whether the events really happened, and so on and so forth. So the idea and the rationale for this common law rule is that reputation testimony doesn't involve the likelihood of having to examine a bunch of tangential facts to determine foundation of the testimony. And that really also applies to opinion here too. So in any event, with our current rule, in the case of a positive character witness, people are limited to testimony about reputation and opinion. There's no right on the direct examination of a positive character witness to ask about or for the witness to talk about specific acts that underlie the basis for the opinion. Okay, so back to Rule 404 again. Remember, once the defendant opens the door by presenting evidence of his good character, the prosecution has to be given the opportunity to rebut, to fight back with evidence of bad character, and that's right there in the second half of 404A2A that's underlined on the slide. If the defendant's evidence is admitted, the prosecutor may offer evidence to rebut it. And the prosecutor can fight back in 3 ways. Again, this is a review of last Wednesday. She can, of course, cross-examine the defendant's character witness. Now, on this cross-examination, this can include asking whether the witness has heard about specific acts of bad conduct by the defendant. And that is actually also there in Rule 405A in the last sentence of Rule 405A, talking about on cross-examination, right? Specific acts can be inquired into. So you should probably, if you want to look at the second half of 405A, you can stop the recording here and look at that rule to confirm that for yourself. Now, I want to point out the fact that when this method is used by the prosecutor, when the prosecutor asks the witness on cross-examination whether the witness has heard about some specific past act, the prosecutor is bound by the witness's answer and can't put on additional evidence that the defendant actually committed the bad acts that the prosecutor just asked about. So no extrinsic evidence of the bad acts can be put on. She can only ask about those acts, asked if she has heard or if she knows that the defendant committed those acts. She has to take the witness's answer. Now we're going to go back to that in a minute, but I do want to go on to mention the other 2 options for a prosecutor in countering a criminal defendant's positive character witness. So number 2, the prosecutor can attack the credibility of the defendant's character witness by actually going after that witness's character itself. And that comes in accordance with the rules for attacking the character of witnesses that we will cover later in the course. But for example, the prosecutor here could show that the person who is testifying that the defendant has a good character is a person who himself or herself has a prior conviction for perjury, for example. That would be allowed under our impeachment rules. This option, of course, is mentioned in Rule 404A3 that references 3 impeachment of witnesses rules that we're going to talk about later. Those are Rules 607, 608, and 609. But just for our purposes now, just keep in the back of your mind that a good character witness can also have her credibility directly attacked. That's sort of in a prosecutor's arsenal here. And the last one, number 3, a prosecutor can also put on her own character witnesses in rebuttal to testify that the defendant actually has a bad character. This is just part of that rebuttal right in Rule 404A2A. So even though a prosecutor couldn't put these witnesses on to talk about the defendant's bad character or bad character trait, to start with, once the defendant opens the door by putting on a good character witness, now the prosecutor can actually put on a character witness to get up and say, well, you know, I'm testifying that the defendant actually has a bad reputation in the community for honesty, or I have known the defendant for a number of years, and I think the defendant, in fact, is a very violent person, has a violent character trait. All, you know, the kind of witness that a prosecutor wouldn't have been able to put on unless the defendant opened up the door. Okay, so of those 3 options in the prosecutor's arsenal, in terms of attacking the defendant's good character witnesses, I would say that the first method is often the most devastating one, and we saw that in the Mickelson case, and that is cross-examination about whether the defendant's character witness has heard about specific bad acts of the defendant. So under the Mickelson case, the prosecutor is allowed to ask if the witness has heard about prior convictions of the defendant, has the witness heard about a prior arrest, or even has the witness heard about, or does the witness know about some prior bad act for which a defendant wasn't even arrested. Now, in all of these cases, of course, there's going to be a jury instruction to tell the jury that it is only supposed to use this specific act question as a means of verifying the witness's actual familiarity with the defendant's reputation, and not as direct character evidence against the defendant. All right, so again, very broad latitude here in terms of asking the witness about past specific acts. But again, that's where it stops, right? So if, let's say, the prosecutor asks the defense character witness about a prior conviction of the defendant, and basically the question is, have you heard that the defendant was convicted of burglary in 1984. Let's say that's the question. And the witness says, no, I didn't hear that. Now remember, the prosecutor can't then put on evidence to prove that past conviction, so no extrinsic evidence about that. So in Mickelson, for example, even though the prosecutor's question referred to a specific act, right, the defendant's previous arrest, the prosecution could not then introduce the fact of the arrest as an independent piece of evidence that would bear on Mickelson's character. But even though the prosecutor here can't put on extrinsic evidence about prior bad acts, just asking the question alone can be really damaging, right? So the question is, why, what's the rationale for giving the prosecutor this freedom? Well, supposedly, again, we put it in a different box, basically. These questions are not supposed to be asked to show that the defendant did the bad acts, right? The purpose of the question is supposed to be just to test the qualifications of the character witness to testify about community reputation or to testify about personal opinion about the criminal defendant. So the idea is, if the character witness hasn't heard about, say, a past arrest, as in the Mickelson case, then maybe the character witness doesn't really know Mickelson's reputation, or in modern times, that the person really isn't qualified to give his or her opinion about positive character. And again, I love that one example the book has in footnote 16 on page 115 in the book. There, the defendant's childhood friend got up at his murder trial as a positive character witness, right? And testified, oh, yes, he has a great reputation for peace and quiet, and I think peacefulness in general. And on cross-examination, the prosecutor asked her, well, have you heard that the defendant has shot anyone in the past? Now here, she said, oh, yeah, he's shot 3 or 4 people. So I guess she had a pretty liberal idea about what constitutes being a peaceful and quiet person. Really, in that case, the defense attorney probably should have thought twice about trying to put on a good character witness at all. But anyway, getting back to rationales here, the rationale for allowing prosecutors here to ask on cross-examination these specific act questions is that if a witness isn't familiar with a past specific bad act of a defendant, then the jury might well discount the witness's testimony, assuming, well, this witness doesn't really know the defendant as well as he or she says, and so maybe we shouldn't take their good character testimony very seriously. But if we're going to be honest, what is the practical effect of allowing those cross-examination questions? The prosecutor asks the witness, have you heard that Mickelson was arrested for receiving stolen goods? Now, if the witness says, yes, I've heard that, the fact of the previous arrest is still before the jury. They're going to assume it's true anyway. If the witness says, no, I haven't heard that, now the probative value of his testimony is lessened, and the assertion of the previous arrest is still kind of before the jury, even with a limiting instruction. So it's really a lose-lose for a defendant, right? Let's say I ask one of you as my former student to be a positive character witness for me, and you do so. And on cross-examination, you're asked, have you heard that your former professor, Lisa Fagman, was arrested for indecent exposure? Now, if you say, yes, I heard that, not only does the jury now think I'm a pervert, right, but they completely discount your testimony, even if later they're, instructed to use it only to go to the credibility of your testimony, they're still going to kind of use it against me. So really, there's a couple of practical practice notes here. Because of this risk of past acts being asked about on cross-examination, we can certainly understand why it's pretty rare for criminal defendants to ever use this exception in 404A2A to put on a positive character witness. It's a very rare occurrence. But if a defense attorney does decide to do this, he or she should be prepared for these specific act questions, and also be prepared to basically object to anything the prosecutor acts in this context, again, because Rule 403, or say if you're in California, Evidence Code 352, you at least have an argument that prejudice might outweigh probative value. You're probably going to want to anticipate those questions and bring it up pre-trial and try to get the judge to not allow a prosecutor to ask those cross-examination questions of your positive character witness. I'm not sure how good a chance you have, but if you do it pre-trial, number one, you might get the judge to say, yes, I won't allow that question on cross because of a Rule 403 type concern. Or if you lose and the judge says, yes, I'm going to allow that cross-examination question, then at least you can reconsider having a positive character witness get on the stand at all. Okay, so the last issue in this area is whether the prosecutor can just pull these questions out of thin air, okay, and make them up? Can a prosecutor just make up questions or use unsubstantiated rumors? Have you heard this? Have you heard that? Now, certainly you saw in the Mickelson case that the court there endorses what is the prevailing scholarly view, that a prosecutor should be required to show that he or she has a reasonable basis for believing that the defendant actually did the bad acts that she's asking the cross-examination question about. Okay, so in order to exert some control over prosecutors, there is this idea that a trial court should not allow cross-examination questions based on pure rumor, and that is generally the case across the board. That's generally understood, and I think that's a really good rule. There's some really interesting mock jury research that seems to indicate that jurors actually assume that the judge has pre-screened and okayed any evidence that the jury hears, and even has okayed questions that are asked by lawyers. So this certainly seems like an important limitation, because how could the jury imagine that a judge would allow this kind of question if the underlying facts weren't true? Okay, so I'm just going to do a recap here on all of this that we've discussed in this video lecture. So Rule 404A2A again tells us that even though in general evidence about someone's character or character trait is not admissible, if you are a defendant in a criminal case, you may put on character witnesses to talk about your good character or your good character trait for the purpose of being able to make the argument that committing the crime at issue is not in keeping with your character. And your good character witnesses can testify about your reputation or about their opinion of your character, but they can't talk about specific acts like all your donations to children's charities or knitting socks for homeless kittens. Okay, so that's how you can start as a criminal defendant. But then the prosecutor can cross-examine your character witness, and the prosecutor is allowed to ask that witness if he or she has heard or if he or she knows about some prior bad act, something that you've done in the past, an arrest or a conviction, you know, or again, even some act you weren't arrested for or convicted of. And the only allowable purpose for these cross-examination questions is to test the character witness knowledge of your reputation or of your character, right? And the jury will be instructed not to use that information to judge your character directly. Still, as we pointed out, it can be damaging just for the prosecutor to mention a bad act or prior arrest or conviction, right? But whether the character witness says no, she hasn't heard about that prior bad act, or whether she says yes, she has heard about it, the prosecutor has to just take that answer. Can't try to prove that you did that bad act by putting on another witness or documentary evidence of that. So he can't actually try to prove that prior act with extrinsic evidence. And again, this is in keeping with that purpose for prosecutor to ask the questions at all. It's only supposed to be to test whether the witness has heard or knows about them. If the witness hasn't heard about them, maybe the jury will think the character witness really doesn't know the defendant that well. And if the witness has heard about them and they're pretty bad acts, well, then the jury might think the character witness has pretty bad judgment about what constitutes good character. So they might really discount that positive character testimony. And prosecutors are supposed to have a reasonable basis for believing in good faith that the prior act actually happened before asking about it. Okay, so that's our recap of all of these issues. I'm going to end this first video right here, and I will go on to video 2.